This session is really about you as much as it is about legal and getting some advice. And I'll let Ted talk a little bit more about the fact that obviously this isn't official. But I'm here to introduce Ted. Ted Howell is probably in Rhode Island. He's his organization, and him in particular, he's the guy when I think who can help startups immediately out of the box and understand all of the specific legal items that an entrepreneur founder needs, especially those that are going to be doing high potential scaling business. So some of the specialty items for that include capitalization and making sure you're setting your company up properly. Certainly intellectual property, certainly hiring, and all of the issues around kind of giving your employees stock options, etc. Lots of different kinds of things that you need to learn. They're very different in setting up a high potential growth startup. And Ted's organization, I've personally used them for my companies. And so when I think about it, I think of that. Now, the most interesting thing to me about Ted is Ted didn't start out being a lawyer. He actually started out being a mechanical engineer. So you got to love that. So he turned into being a corporate lawyer with really that focus initially on advising entrepreneurs. He does take a practical approach. It's geared towards growth, relates to the formation, management, protection of assets, financing, and sale of your business. By the way, setting up your business today will have a lot of, a lot to do with how easy or difficult it'll be later if you're going to do a sale of your company or sale of your assets, I should say. So all of this stuff is really important. He does take an engineering approach, which really turns complicated systems into something more simple and manageable. When it comes to legal advice, wow, what could be more complicated? We don't want to become lawyers. We're entrepreneurs and we're starting our business. So he does like to brainstorm with his clients about various legal and business structures and strategizing. So you're going to get great advice, not just sort of a off the shelf, here, use this contract kind of advice, which can happen. So he's going to be bringing sort of all of these elements to the table. And anyway, I'm thrilled and honored to introduce you to Ted Howell. And by the way, this is meant to be a clinic. So he's going to do some talking and invite you all to ask questions. So this is a case where you certainly could put it in chat, but you're probably welcome to unmute, and we'll let Ted run that. So take it away, Ted.
All right. Well, thank you so much, Annette. If you ever need a job in marketing, I think we've got a place for you. It was so kind of you. Yeah, I'm thrilled to be here and to talk to all of you. As Annette said, I really hope to have something that's a little more interactive with you. I've put together a group of things that I'd like to discuss that I'm gonna just briefly give you an overview on. But honestly, it would take me 3 hours to go through these things in detail. And so what I'm really hopeful is to see people raise hands, unmute, ask questions, or use the chat and help give me some guidance in the areas where you would like me to talk. So in particular, I'll start by saying, give you an idea of who we consider our clients, who this really applies to. And it's really early stage startup companies. We're an early stage startup company. A technology company usually is a company that is building or relying heavily on technology, usually has a high growth trajectory. It's likely growing with outside funding. And a lot of our clients are even before Series A. And I suspect, a lot of people here are as well. Although I do see Pat Sabatino here, and I know otherwise for him. They say that 9 out of 10 startups end up failing, and I'm not going to cover everything here in terms of mistakes that we see startups make, but my thought process is to kind of go over some of the highlights of some of the big ones. And the big ones that we see typically revolve around forming the legal entity at the wrong time, if you're going to use a legal entity, and when you should form it. Choosing the wrong kind of legal entity. So not all legal entities are equal, but so it's really important to make sure that you get in the right one from the ground floor. Lack of legal follow through, and potentially choosing the right platform, whether that platform is a lawyer, whether it's an online service or otherwise. Promises relating to equity and what you're going to be granting to people. And the way those promises are made can actually make or break an organization. Equity without vesting, and that kind of goes into the same category as the promises relating to equity. Failing to protect IP. And then the last one that I have on my list relates to securities laws, because a lot of people tend to forget that securities laws apply to a lot of the things that we're doing when we're working with a startup. So that's kind of a general overview. Once again, I would ask people to interrupt me, but if I don't hear otherwise and I don't see anything that piqued anyone's interest, I'll just start by going through forming the legal entity. Anyone have anything in particular on that list they're interested in? All right.
All right, get your burning questions out, folks.
Yeah, get them out. So I'm going to start with forming the legal entity. And if I'm looking to my left, don't worry, it's not that I'm lying. I'm looking at my notes. So one of the big problems that we see often as it relates to forming an entity is the timing of forming the entity. And believe it or not, there are quite a few people who form it too early. And then there's some of those who form it too late. And I would imagine you'd be really surprised to hear from a lawyer that, wait, I formed the entity too early? What do you mean I formed it too early? Don't you want our service, us to pay for your services to form an entity? Doesn't it limit our liability and so forth, so on? And there's somewhat of a feeling amongst a lot of entrepreneurs that it's real once they've formed an entity. So they rush out and they spend the dollars to form something. They either rush to an attorney or perhaps they use LegalZoom or one of the other services that exist out there. And the problem that's associated with that really is one that involves money. A lot of the times that we see companies do that, a lot of times they've gone into the wrong form of entity. And going into the wrong form of entity, I'll get into that in my next point, but that can be pretty disastrous. A lot of times they didn't really need an entity, and or it was just an idea, and forming the entity just ended up being a waste of money, because it's not just about your formation fees with the Secretary of State and the legal fees associated potentially with putting documents together as it relates to your entity, but it also goes to ongoing requirements to maintain that entity, and even, believe it or not, to terminate it. I mean, I had a situation with a company that was based in Rhode Island, and it had operations in Connecticut, and it had never qualified to do business in Connecticut. And just as an aside, businesses, they have to qualify in every jurisdiction where they're doing business. So they had to qualify in Connecticut, and they came to me because they were selling the business and they had to make an opinion that they had always been qualified everywhere that they were doing business. In that situation, because they hadn't qualified in Connecticut and they hadn't done the things that were necessary, it cost around $30,000 to fix the mistake that they had made. And so you may ask yourself, why did they incur that cost, or did they actually need to? And a lot of times, had they not even formed an entity to begin with, they wouldn't have incurred any of those costs. And so there are situations, believe it or not, where you can form too early. Any questions on that? All right.
I have a general question. We entrepreneurs, one of the most important things for us is cash, money. And so in the early moments when I'm sitting there at, 12:30 at night and saying, I'm about to make a sale, I better get an entity. Why would I go to a lawyer who's going to charge a bunch versus just going out to LegalZoom and seeing if I could cook it up at my kitchen table, as they say? Why,
Ye-
why would I go to you versus going to LegalZoom? I get this
Yeah,
one, by the way.
it's a really good question. And it's something that I was going to get to later, but I'm gonna get to it right now. And it's what I talk about in terms of both follow through and choosing the right platform. So LegalZoom actually works quite well for some organizations. Organizations that are less specialized and have a relatively simple capitalization structure. When we're talking a technology startup, the issue is that oftentimes we have a very complicated capitalization structure, or anticipate having a very complicated capitalization structure. And just to reel it back a little bit further, this is because oftentimes a technology startup is funding its operations through outside investors, right? And that are investing in stock of the company, rather than, being able to get traditional bank debt, or, just taking a loan from mom and dad for, $5,000 or $10,000. Usually we're talking large amounts of money to get the idea off the ground. So all of that translates into a company that has a very complicated structure as it relates to the type of stock or interests that it's issuing, as well as the rights and privileges that relate to it. And LegalZoom is not built for that. LegalZoom is built for a person who's going to go out and maybe wants a single member LLC. They're starting maybe a restaurant business or something like that, and they just need to protect themselves from outside liabilities. And they don't need a highly specialized type of entity in order to be able to attract and prepare themselves to attract the type of investment that's needed to have a successful startup company. Is that good? All right.
Thank you.
Yeah. So I'm gonna step back a little bit, and I'm gonna talk a little bit about, when you should be forming an entity. And because I think you brought up a good point there, Annette, in terms of, okay, I'm going to be signing a contract tomorrow and I need to form an entity. So some of you may be asking yourselves, well, why just signing a contract would I need to, why would I need to form an entity for that? And the presumption there is that it's liability based, right? Presumption there is that, well, an entity is going to help me protect my personal assets from the liabilities of the organization. So if I enter into a contract through the organization, the contract has the entity has obligations under the contract, but I don't personally. Okay. And inherent in that, there are a couple of important points. Well, one important point there is that you don't personally sign the contract, even though you form the entity. And that's part of the legal follow through I talked about. It's also understanding the terms of your contract, because there are a lot of contractors out there who recognize this issue, and they have you personally sign a contract, even though it's with an organization, in which case the entity is not doing a thing for you anymore, right? The other part of that is that the organization isn't truly going to protect you unless you're truly treating it as an organization. And in order to do that, there needs to be a lot of follow through involved in terms of having bank accounts, having a separate balance sheet, and treating the organization like a separate entity. And then the third part is relates to personal liability that can't be shielded through the organization. And as an example for that, I always like to sort of give an egregious example, which might be, you're doing a delivery for your company in your car, and you decide to drive, 100 miles an hour down Route 95, and you get in an accident and your insurance doesn't cover it, and you get personally sued. You can't hide behind the shield of your organization when you've engaged in personal activity that's reckless like that or negligent. And in that same example, if it had been a worker for you or one of your staff that had done that, you would be shielded from the liability, at least personally associated with that. The business would see the liability, but you personally as a shareholder, since you weren't actually personally negligent or reckless, you wouldn't see that liability, and the organization would shield that liability. So that's one reason to form an entity. And that would be one time point when you're entering into that big contract. The other aspects that really more specifically relate to startups really hinges on the number of people involved in the organization. And what happens oftentimes with startups is, if it's just you, if you're just a solo person and you're developing, say, some software or a software platform, you probably don't have too many concerns about ownership of that software. But if you have partners that are helping you, that's when a legal entity starts to become pretty important. And the reason why it's pretty important is because we've got to make sure that the software is owned by the entity. And then the entity gives us a platform not only to own that software, but also to put together an agreement as to how each of the stakeholders are going to share in it, right? So each of those shareholders, how are we going to represent the ownership of the product that's being made now that we've got it within that entity? And so oftentimes, when a client is coming to us and they're asking us, or a potential client, do we need to form yet? A lot of times I'm focusing on how many people are involved and, what type of contributions they're making to the entity. And if those answers are, that we've got several people coming on, I almost always want to get them into an entity. And think of it this way. Let's say, you're working with, your friend from across the street, and, maybe you've come to some agreement with them that you're going to give them some equity for the work that they've done. But then things don't go well. And maybe that person down the street doesn't put in as much as you wanted them to put in. And so you say, no harm, no foul. We never had an agreement. I never formed an entity. It can be a real problem. That person down the street can be a real problem if they can show that they've contributed and therefore are entitled to some ownership of that entity, and or they can make an argument that they were promised something that they weren't given with respect to that entity. And so when I start to see those multiple people, that's another area where I really, really, really start to get nervous. In those cases, the entity almost acts like a prenup agreement. It's almost like I'm thinking about what happens if you separate. And in reality, it's with a startup, since they exit, there's always a separation, or almost always a separation, right? And it's just a question of who gets what once the entity is sold and or you separated. And so it's really important to get those documents in place early, set the foundation so that people can then move forward and be motivated, and you don't run into those problems that can be really costly down the road. So I'm seeing a couple notes here that I'm going to touch on. Learning more about making promises of shares equity would be a priority of mine. Thanks in advance. And how many of us have been through that? Thank you, Judy.
Well, and by the way, I also want to just again tell people, when those questions come up, please put them in the chat. This is what we want. We want interaction. So
Yeah. Yeah. So how many of you have been through that? How many of you, so Tuna, you've been through that? Hopefully not too many times. Hopefully you learned the first time once. Anybody else? All right. Well, with that, let me.
By the way, I've gone through where we had to get founders out of a company.
Yes.
That's not easy either, where there's like real documentation, they have ownership, and that ownership is vesting and is vested so much, but not all of it. And it's a very complicated transaction to get them out.
Yes. And if they don't have documents, it can be even worse. But even when they do, I've been through those situations as well. And it never ends well. I've seen several companies just die as a result of the person leaving, asking for too much. I've seen a lot of hurt feelings. Our goal in actually setting up that entity is to make sure that everybody's on the same page. And so there are no surprises when that separation happens. And as I said, in reality, it always happens, right? Because you're not planning on running this company forever, or at least most people aren't. All right. So let's talk a little bit about then the promises for shares and equity and some of the mistakes that I've seen made there. So I'm going to skip down just on my list here.
And by the way, while you're thinking about that, I'll add, there's a lot of ways that the founders can leave. They can get another job. I've had that happen. They can die. I didn't have that happen, thank goodness. Or you might want them gone. Like any of those could happen. So,
or your investors might want them gone.
Or the investors want them gone.
And we've seen that happen a lot as well, right? So let me start by saying, I want to talk a little bit about a capitalization table and make sure that people understand how it works, because I don't think there's confusion about it, but there's somewhat of a misunderstanding. A lot of people talking, what kind of percentages should we be giving such and such people? And the biggest problem that I run into when we start talking percentages is, especially the engineers, so I can make fun of myself, we start making pro formas and projections. We assume we're going to get X amount of dilution. And for those of you who don't understand what I'm saying, you can only have 100% of a company. You can never have more than 100%. And so when you're granting equity to investors and to other people down the road, each one of those grants is reducing the percentage that the people before them had in the company, okay? So if you started with 50-50 ownership and you brought in an investor that bought 20% of the company, those people who had 50-50 now have 40-40 and the investor has 20, right? So it's really important to understand that concept before we go too much farther. And a lot of people, for whatever reason, they look at that and they say, well, I want to at least have 5% when I exit. So they try to make up for it now. We always tell our clients, don't do that. Look at the relative value that you're bringing to the company now in the current time, and make your decisions based on both that and on the projected value that the person's going to bring. And the reason we talk about projected value is because oftentimes, people aren't getting paid much. So what we try to do is give people equity in advance that's subject to vesting, which is very important. The vesting allows you to take the equity back if the person doesn't fulfill the goals that you've set for them, right? And so a cap table, you can never have more than 100%. Everyone likes to talk in terms of percentages, but here's the traps that they fall into. Number one, they get to a point where they've granted somebody too much equity. And as a result, the people who are really valuable to the company have less equity. And that makes the company less attractive to both investors, but also tends to reduce the valuable people. It tends to reduce their desire to continue pushing forward with the company. We want them to be as incentivized as possible. And so debt equity, that's what I call debt equity. And debt equity is a bad thing. So you don't want to have large chunks of equity going to people that are no longer contributing to the company or have not put cash into the company. All right. So you want it to be tied to an active participant or a contributor of the assets or capital. All right. Another
And Ted,
area.
can I interrupt one more time? Can
Yeah.
you also talk a little bit about the idea of sort of envisioning over time? So for example, the people that might be really important to my company today, those folks that are, maybe building a platform versus the, really big deal marketing executive I need to hire, and I need to give that person some really serious equity later, or maybe a new CEO, or et cetera. How should we think about that over time piece? Because what is the slice of today, it's going to look different maybe in a year, 2 years, 3 years.
Well, so you can plan for that to a certain extent, Annette, with an option pool, right? Setting aside a number of shares. If you know that you're going to bring in a CEO and you know that you want to give up, say, 10% of your equity for that CEO, what you can do in the beginning is you can start with 45, in my other example, 10, right? And then go from there. But what I always like to say is, think about what kind of contribution you expect from a person, both now and over the next 4 years, and think of that relative to everybody else who's there to determine your percentage, knowing that you're all going to be diluted pro rata, because there are going to be unanticipated circumstances, and this is why you need to have vesting schedules to pull shares back if things don't work out. It's hard, and this is important to understand, it's hard to just grant more equity to the people that are contributing. And the reason why it's so hard to give more to the people that are contributing is because as the company grows in value, there are taxable impacts to giving those people more equity. And so it's important to be thoughtful about your relative contributions to begin with, and once again to have those vesting provisions to bring things back if in fact things don't work out. And to your point, Annette, if you know that there's going to be a need for certain types of equity, you can set that aside now. And that can be very helpful in helping to determine. A lot of companies, we see this all the time, and I use it myself, right? Because it's easy math, right? You'll have two founders who come in and say we're 50-50, or they have three founders that come in and they say, well, we're a third. Whenever I see that, I push them hard to really, and I push each one of them. And I say, do you really think you're equal to those other two in terms of what you're bringing to the company and in terms of what you expect to bring to the company over the next 3 to 4 years? And if the answer is no, then you've got the wrong percentage. You've got to, it's somewhat of a negotiation, but you've got to address it. And if you don't address it properly up front, you end up with people on the cap table that probably aren't as deserving. And you end up with a company that is potentially not as, the investors don't like to see, as I said, that debt equity. They want to see the people who are the real superstars with the larger chunks of equity and keeping the company going forward. So that's part of it. The other part that I see often, and it just drives me bananas, is, people will come in and say, well, Uncle so-and-so is an investor and he's willing to put in $100,000, but he has to have 5% of the company for that. And so I told him that he's going to have 5% of the company. And in essence, they're saying that he's going to have 5% no matter what. that he's not going to be diluted down with the others. He has essentially anti-dilution protection. And what I'm here to tell you is that that will kill a company. And in order to understand why, there are a couple of concepts that you need to understand. One is that companies usually have multiple layers of investment as they go through their life cycle. And each layer of investment, last money in is usually the first money out in terms of if the company has an exit, right? So the last investors that came in are entitled to their money first, and so forth, so on, all the way down the chain. Just as important, you need to understand that that percentage, that 100%, can never change. And so when you think about it, if you're promising your uncle 5% of the company and he's never going to be diluted below that 5%, who is going to take that dilution for him? And I'll tell you who. It's going to be the founders, first and foremost, right? Because every time an investor comes in and dilutes down, you're going to have to grant that uncle more shares. And in essence, the investors aren't going to say, oh, that's fine, we'll take less of the company since your uncle has anti-dilution. They're going to negotiate the terms that they want to have, and they're going to say, no, that's going to come out of the founder equity. And so the founders are going to be reduced, and the founders are taking the hit each time. Potentially, investors are taking the hit, although hopefully they would be smarter than that. But if you think about that sort of ladder in terms of last money in is first money out, then each time there's an investment made, those prior investors are all diluted pro rata, right, with the founders. And so if you have somebody on the cap table that has this pure anti-dilution protection, those investors are also going to be taking a share of that dilution, and they're not going to be happy about that. And they're probably, unless you're able to negotiate out of it, they're probably may even say, well, we want anti-dilution protection as well. And we want the same anti-dilution protection. And you can see how very quickly a founder ends up with nothing, or a very small percentage of the company, and ends up giving it away by virtue of this, this common mistake with the uncle that they promised 5% of the company. I should point out that there are situations where what we call anti-dilution protection is given, but it's not in terms of setting somebody's percentage of the company. So it's very typical to give investors, as an example, anti-dilution protection. But it's anti-dilution against the value of their investment. It's not against a percentage of the company. And so as an example, if an investor paid $1 per share, their anti-dilution covenant wouldn't be triggered unless you made a subsequent sale to another investor at less than $1 per share. And in that case, they get an adjustment to put them in a better position, but they're not getting this set percentage.
And Ted, that's you're answering Julie's question.
I'm looking at her question now. Is it?
Yeah, good. Okay, because in this case, I mean, I would always, as the CEO, I'd always really try to negotiate that out, that anti-dilution thing. But it is exactly why you want to, back to my original question, should I go to LegalZoom or should I go to Ted Howell and his group? These are the absolute questions you need to work with somebody like Ted on. You really can't do this on your own as many times as I've done it. You have to do the what ifing in those cases. So, yeah. Yeah.
And to answer Julie's question, so if Julie is going through an equity financing right now, there will be something on the term sheet that says anti-dilution protection. Make sure that it's weighted average anti-dilution protection. Those are the magic words. And what that means is that in that scenario that I gave, where you issue this investor $1 per share and a subsequent investor for 80 cents a share, what that means is that they're not the prior investors are not given the benefit as if they had come in at 80 cents, but instead what a weighted average does is it looks at how many shares were brought in at 80 cents a share, right? Because if you only sold a small number of shares, it shouldn't have as much of an impact and as much of a a calculation as it would if you sold half the company at 80 cents a share. So the marketplace is, when it comes to preferred securities, is to offer what's called this weighted average anti-dilution protection. But definitely at the founder stage, don't agree to anti-dilution. Early friends and family investors don't agree to anti-dilution. Those are company killers.
And I'll just pause and say, anybody else have other questions? George? Yeah.
Yeah, sorry, just to follow up on that. What's the default rule? So if the agreement is silent as to whether the 5%, for example, is subject to anti-dilution or dilution, where does the law come out on that?
So the default is that they'll be diluted with each new issuance, and it would be a pro rata dilution, and that works by just understanding that capitalization tables are additive, right? So in that example where I said 50-50, if you had started with 100 shares and you brought on an investor that was buying 20% of the company, they would have bought 25 shares and the company would have 125 shares after that, right? And the 50 divided by 125 is 40%, and so forth, so on. And that's what happens as you bring in more and more investors, your capitalization grows. And so it's simply a formula. How many shares you have divided by the number of shares that you've issued.
Thank you.
Is that helpful? Yeah. I see another question here. How much time, money should I expect to spend to have a conversation about this topic? My current articles of organization have me as an LLC. Does it cost to add a cap table? That's Nick. Can I say Nick or Nicholas? What do you prefer?
Nick is good.
Okay, so
I meant to add single member LLC. Sorry about that.
So you're okay. Single member LLC is not necessarily a bad place to start. And I see one thing I will say while I have the opportunity to say it is, if you're in a tech startup, do not form as an S corporation. I'm just going to put that out there right now. An LLC is not a bad place to start. A lot of companies end up being in a C corporation, but there's sometimes good reasons to start as an LLC, and a lot of them are tax-based, right? As an LLC, all the taxes flow through to you. If you're putting your own money into the company and to its development, it's a great place to be. It's inexpensive to form, and the cash that you put in, a lot of times you can take it as a deduction on your tax return as a business expense. And so if you have another source of income, you can reduce your overall taxes, and you get to an S point, you can save some of those precious dollars up front to pour into your development of your product and your company. Now, your question, Nick, is a little bit loaded. How much does it cost to create a cap table? The cap table is created by virtue of bringing on other stakeholders, I'll say, rather than shareholders, because that's corporations and otherwise. An LLC starts to get a lot more expensive once you start bringing on other stakeholders. And one of the reasons is especially in the startup world, is that a C Corp has become sort of the de facto entity to go into. And there are a lot of good forms for Delaware C Corps. We can form them, especially if we follow the standardized documents, relatively inexpensively. If we do so we have a partnership with a company called Clerky, another with Shoebox. There's sort of these online I hate to call them LegalZoom because they're good, but they're like a LegalZoom for startups. If you use those, you can bring your costs down significantly. And in fact, we do that when we form entities. And what we'll charge is sort of an upper level, depending on your circumstances, of maybe a couple $1,000s. And then there's usually through us something like $300 for the platform. So that's for a Delaware C Corp. For excuse me, I don't have itchy throat. For an LLC, it can be anywhere from 2,000 to 10,000 and up. And the reason is because LLCs are very, very flexible, and we can write in it whatever we want. And so when we have somebody who comes in, well, we want to treat this person this way and that person that way, they start to get very complicated. They also get very complicated from a tax perspective. And so I think your first question, Nick, is, should I still be an LLC or should I move into a corp?
And Ted, along those lines, is it true that if I start my company and I fully expect that I will need institutional investors, by that I mean venture capital, even angel investors, that a C Corp is what they're more comfortable putting money into, or would they put money into an LLC?
So we've seen some circumstances where they put money into LLC. Some of them are big names, but even those entities eventually went to a C Corp. The reason why investors might like an LLC, especially like friends and family type of investors or smaller angel investors, is because of what I just told you in terms of the tax benefits of taking losses on their tax returns. But there's a very good reason why most sophisticated investors want to go into a C Corp. And it's a section of the tax code called Section 1202. And it relates to qualified small business stock. And under that provision, if your company qualifies as a small business, there are a number of hoops that you need to jump through for that, but it needs to have less than 50 million in assets, and couldn't have started as an S Corp, by the way, which is why I said don't start as an S Corp. Could start as an LLC and convert over. But if the investor invested in that entity and held the stock for 5 years or more, then when they sell the stock, they can take the greater of $10 million or 10 times their investment free of capital gains tax. So, they invest, $1 million into a startup, and the startup has an awesome exit and they get $10 million, no tax, right? That's the main reason why investors like C Corps. And they like the C Corp to be in Delaware because Delaware has the law of the land when it relates to corporations. So, most investors don't want to get hauled into a court in Warwick, Rhode Island. When it comes to shareholder issues, they want to rely on sort of the law of the land, which is settled in Delaware. So that's why you hear so much about Delaware C corporations. The other thing that investors will tell you is that, the more sophisticated investors that are in venture capital funds, they don't want those K1s, right? Mm-hmm. They don't want those statements coming from the partnership telling them their portion of profits and losses. It makes their taxes more complicated. And if they have foreign investors, it gives those foreign investors a real problem because they're now seeing income and loss and on tax returns in the U.S. So
I have one more question around this, if you don't mind.
Yeah.
Sorry, I'm out of all the questions. So one time I made the mistake of going the LLC route early on, thinking, oh, I'm going to save money. And then eventually, as the startup CEO, I recognized that I could leverage ownership in the corporation much more easily, at least I thought so, by having a C Corp, and giving away stock options versus LLC. You know, in other words, I leveraged stock options heavily in the beginning to say, you want to write some code for us, we're going to give you a good chunk of this, et cetera, et cetera. Am I wrong on that? Was the LLC also, can you also do that with an LLC? And what do you give away units or something? It just seemed more complicated to me. So then I took my LLC and then made it a C Corp, and I spent way too much money on that.
So an LLC, you can do that. Okay. And LLCs typically do it with what are called profits interests. But there are issues with that, which I'll get into in a second. But primarily, that is a choking point that we look at, and we look at converting for a different reason. And the reason is that it's expensive to develop those plans for an LLC. And if you eventually convert to a corporation, you can't just take those plans and say, I already spent the money on it, and apply it to the corp. It's done. It's worthless the minute you convert to a corp. So when a company gets to that point where they're like, okay, we need to have these plans put in place for our employees, we have to really think about what's the value of them staying in an LLC, and does that value offset this money that they're essentially throwing away by putting that employee plan in place? The other aspect that I was alluding to with profits interest, the way a profits interest works, by the way, is instead of a stock option where a person's given a right to buy stock at a set price, right? And that price is the fair market value. That's to avoid taxes. In a profits interest, instead, they're actually given equity in the entity, but the equity doesn't entitle them to any value until the full value to be realized exceeds the value on the day they received it. So if it's worth 50 cents on the day they receive it, there needs to be 50 cents in distributions or payments to all other units before they get anything, right? But as a result, they're an owner of the LLC. And as an owner of the LLC, they can no longer be an employee, a W-2 employee. So that's the other issue you might have been running into, Annette, is that now, and if you want to grant this equity to employees, you can't pay them on W-2s anymore. They're officially partners for tax purposes.
Yeah.
And so yes, there are a number of issues that usually start to push us towards a corp when we see that. And the only time that we don't see that happen is when you see people with a lot of money who want to have the tax benefits of the potential write-offs, whether that's the founders or somebody else.
That's really helpful. I just want to do a check-in with everybody. We have about 10 minutes left. So if you've got that burning question or two, let us know.
All right. Well, I'm not seeing anybody there. So how do people feel about vesting? Should I talk about vesting a little bit? Does everyone understand how vesting works?
I think it's important because I answer this question pretty often with a lot of entrepreneurs where they're concerned or worried about giving away equity to somebody, to an employee coming in. And that whole notion of vesting wasn't really on their radar.
All right. So first and foremost, I've circled around these concepts, but I haven't really pulled them together for you yet. Let me answer the question, why even have vesting, right? It probably, in most of your minds and just about anybody who's logical, it would make more sense to just reward people with equity as they contributed to the company, right? Let's just give them more as they contribute more. I don't want to give it up now. I want to see how they perform and then give them, the equity as and when they perform. The reason we don't do that is for tax purposes. And I don't want to bore you too much, but just know that the IRS deems any of those issuances of stock to be taxable to the recipient of the stock to the extent that they pay less than fair market value. And that fair market value is pretty subjective. Unless you go out and get what's called a 409A valuation done, you've got to prove to the IRS, if they come in and audit you, that your valuation was correct. And if it's wrong, there are consequences. So as an example, if you gave, someone who's acting as CEO shares of stock for a penny, and 6 months later the company sold at $10 per share, you can bet the IRS is going to audit it, and they're going to assess a lot of taxes on that CEO. So all of this goes back full circle to why we give out so much stock up front. It's tax effective to do so. The company's worth nothing, and we can make a very strong argument to the IRS that the company's worth nothing. And so we grant this stock now in hopes that it's going to attain much more value down the road, and anything we see hopefully won't even be capital gains, except to the extent it's over $10 million, right, in capital gains. So that's the way we do it. But then you say, well, now I've got to get the stock back if somebody doesn't perform. And that's where vesting comes in, and why vesting is so important. And what vesting does is typically time-based. You'll hear everyone talk about 4-year vesting with a 1-year cliff. And what that means is that they're given all this stock, but they're really not entitled to any of it until they finish their first year of service with the company. And when they finish that first year of service, a quarter of it has vested. So they now have a quarter of it. And then from there, it usually vests monthly until you get out to the 4-year period. And the idea there is that, well, if they were there for a year, they earned that quarter of it. If the company instead decides that maybe they gave too much to that person, well, it's incumbent on the company at that point, and I just recently did this, to renegotiate those terms. I mean, I literally had a company, one of our clients literally brought in a CTO, did not like how much equity he gave to them, thought it was too much. The investors agreed and terminated him in order to prevent the shares from vesting, and then offered new employment with less equity. So you could do it. Now, in most circumstances, we would probably try to negotiate that instead. But it's very important for a company to be able to do that, and to be able, because the equity is kind of the most valuable thing you've got.
I have a quick follow-up to that. You mentioned time vesting. Is it common to do performance vesting? Are there any drawbacks to that? Do you see any tax benefits, or just curious your thoughts on performance vesting versus time vesting?
Yeah, there's no tax benefit to performance vesting. The issue is that it's the unknown. One thing that I've learned from representing lots and lots of companies is that the company almost never ends up how anybody anticipated, right? It's kind of like the weather. Like, you might be able to say, oh, I think there'll be a hurricane next summer, but you have no idea when it's going to be. You may follow a general trajectory, but you have no idea where it's going to go. And it's the same as with, people who come on board. A lot of times they don't perform in areas where you expected, and they outperform in areas where you didn't. And trying to capture that can be arduous, time consuming, and just end up being wrong. And so we usually advocate for time-based unless there were sort of very, very specific promises made. And I should warn you, don't base vesting on investment coming in, right? Until the rules at least change. That makes a person look like a broker. So I'm going to warn you on that one right off the bat. A lot of times people will say, well, we'll have you vest your first 25% when we get our $1 million in investment. And there are problems with that from the securities law and brokerage issues. But to answer your question, we usually say with time-based, because what that allows is whoever is running the company to make those decisions that are difficult and determine whether they think the performance merits it. It's typically going to be the recipient who might try to negotiate specific milestones, especially if they're ones that are part of the deal of what they have.
Thank you. That's very helpful.
Yeah.
Great. We have about 4 more minutes or so. The time has flown.
It always does. All right, so I mentioned securities law a little bit. For those of you who are going out and getting investment through safes and convertible notes and using online forms and things like that, just beware, those are subject to the securities laws. That's not something you read when you pull all those forms, or unless you do a little more digging. And the securities laws are not necessarily hard to comply with, but you need to comply with them federally and locally in every single state where an investor resides. And that can be expensive. And if you get it wrong, it can be even more expensive, because it means that the people who put money in can ask for their money back and potentially get it back. And if you end up really doing it and messing it up and having it wrong, you could be prevented from ever getting an equity investment again by being labeled as a bad boy. So what I would say to you, for those DIYers out there, obviously don't DIY, but if you do, because, I DIY some of my things too, make sure that all of your investors are accredited investors as a starting point. If you do that, you're 95% of the way there in terms of complying with the securities laws. The other thing, like I just mentioned, don't make any promises to anyone based on the amount of funds that are coming in, because that can be a real problem under the securities laws. If you keep those two things in the back of your head, then there's a good chance that when you do hire a lawyer or somebody comes in, that they're going to be able to smooth over the bumps that were created by virtue of not doing that securities laws analysis from the start.
And I'll add, Ted, it's a little bit like brain surgery. I mean, and I find that even the smarter people out there starting companies sometimes think they can figure this out, this being, sort of the legal framework. And I just tell people, do not, because there's too many things you can't possibly know if you're not studied in legal. Also, I will also say, find a law firm like Ted's that actually practices in entrepreneurship, startup law, because the topic areas are very different than sort of the guy or gal on the corner who is, a very reputable and wonderful lawyer, but they are more generalist. Whereas, find people that understand this whole capitalization piece is big, and that structure around it can get you into some really hot water. So
it's really the things you don't know that get you in trouble. And they may not get you in trouble, but they very well may. We've seen enough problems. We tend to know where they are. So, yeah.
I don't know why I can never remember when I'm doing this. It's a taxable event when you give somebody stock options.
Yeah.
It's like, I keep forgetting that. Like,
well,
yeah.
I'll tell you, Annette, the thing that I always like to say to people, because you'd be surprised how many people say this to me. They say, why is it taxable? I mean, I'm giving them the stock in exchange for their services. And I tell them, you just proved my point. And they said, what do you mean?
Yeah.
I said, well, when you give them money in exchange for their services, isn't that taxable?
Right.
And they're like, oh, yeah.
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 So.
Yeah. And so a lot of people do forget that.
Go
ahead.
I was going to say, there was one other question that's a completely different topic. Julie wanted to say, is there such a thing as a ballpark estimate if you need to go get a patent? How much is that going to cost you?
Yes.
is
So
there such a thing?
I'm not a patent attorney. Dan Holmander is. It's a good question for Dan Holmander.
Tomorrow.
They will give ballparks, but they're going to want to understand a little bit about what that patent is. And the reason is there's a difference between submitting an application and submitting a good application. And there's also tends to be a lot of work beyond just submitting the application, in terms of trying to what's called prosecute the patent and to give you the protection that you need. And a patent has what are called claims associated with it. And it's all about those claims. Like a lot of people will say, well, I've got a patent in this thing. And what the claims are is, what is it about that thing that you have a patent in? You don't have a patent on the whole thing. You generally have a patent on a small aspect of it. And a good patent attorney is going to help you get as big an aspect as possible. But that process is generally going to be more costly.
Well, thank you for that. And if you want to hear more about IP, get on the website, look it up. Tomorrow, there's an entire session on intellectual property. And it's really at the 1 o'clock, exact same time frame tomorrow, 1 o'clock. And thank you, Ted. We can't thank you enough. We recognize you barely scratched the surface of all the issues.
Yeah.
I'm just hopeful people understand to keep yourself out of hot water, you need somebody like Ted and his team. And again, thank you for everything.
And everyone on this call and everyone who is here should feel free to, I will always do a free consultation, right? And I'm not going to do a number of them where I help you form your company for no cost. But I will get on the phone. I will talk to you. I'll try to help, and I'll try to be honest about whether I can help or somebody else can help, or there's something else that you can do. Don't be afraid to do that. And I'm happy to help out wherever I can, even if it doesn't end up in a paying relationship.
Wow, that's great. Thank you again. And hope you guys have a great rest of your day. And let us know if you got any other questions. Thank you.